hearing is now resumed.
Good morning, Mr. Commissioner. Wendy Baker for the Commission with Micah Carmody. Just to bring us back in time, we're completing our panel on gravel with Ms. Julia Baranaducci and Jason Wong. And the questioner today will be Brenda Gartner for First Nations Coalition, and then I think that will be the completion of this evidence. Thank you.
Good morning, Mr. Commissioner. Brenda Gartner for the First Nations Coalition, and I just wanted to take a moment, Mr. Commissioner. There are many things and many challenges in this inquiry, and I regret very much the tension that I created in the room earlier this week during the period of time of objections, and I appreciate that I didn't hear correctly the hockey metaphor that was going on, and so I overreacted, and so I just wanted to extend my apology to this room and to yourselves for that reaction, and I'll do my best to try to understand the hockey metaphors as we move forward. I wanted to take us to Exhibit 1078. And Mr. Commissioner, I thought this would be a good place to start. I had a couple questions, but it will help me to frame the questions that I have. This is the present management committee and technical committee structure that is being used for the review and decision making around gravel applications. Is that correct?
Sorry, yes it is.
Thank you. And I notice there are two chairs, and I take it that those two chairs are actually decision makers in their own respective responsibilities. Is that also correct?
You're referring to what's labeled currently as DFO and
Yes.
the MOE chair, and they are two co-chairs.
And they're also decision makers with respect to these applications.
Under their own legislation, yes, federal and provincial.
And then EMBC.
Can I just offer a small clarification on the DFO side? And I think I spoke to it during the earlier portion. I signed the Fisheries Act authorization for these works, but our decision process is vetted up through the Regional Director General and then back down for that kind of approval. So there's more structure there than is dictated by this org chart.
But in the context of this org chart, the two bodies that are actually required to make a decision are DFO and MOE.
Sometimes transport has to make a decision if there's a navigable waters related issue.
Okay, that was exactly my question. Why was Transport Canada there? So could you explain that to us, Mr. Wong?
It's pursuant to the Navigable Waters Protection Act, and sometimes the works that are proposed have structures like, say, a bridge crossing or something like that that may require a permit under the Navigable Waters Protection Act. So the purpose of these committees is to try to get the agencies with the relevant legislation together and coordinated so that the I guess the activities are permitted in a bit more of an organized way.
And Ms. Baranaducci, could you tell me why ILMB is there?
Yes, and I don't know if we'd like to go back in time, but we have had organizational change and new names. So for clarity's sake, I'm happy to refer to the old labels, but ILMB is now Forest Lands and Natural Resource Operations, as is MOE.
All right. And it's EMBC that's actually the proponent, as distinct from the agency that is making a decision. Is that a fair characterization?
Emergency Management BC is the proponent. And just returning to your question regarding former ILMB, now FNLRO, that representation on the committee is regarding Crown lands and the Provincial Land Act.
So this is a question for both of you. I don't know who best would answer this. It appeared from the science panel, in particular questions that were posed to Dr. Laura Rempel, that the fact that these requests were made, are being made from the province for public safety weighed heavily in the consideration, not so much for if but how these applications were going to be made. Who is responsible within the province or the Department of Fisheries and Oceans for assessing whether they're actually necessary for public safety?
Within Fisheries and Oceans, we consider that under the habitat side of our program, so the piece that I'm involved with and that Laura is involved with, and we evaluate the proposal as it comes forward on the merit that it's brought to us under. So in this circumstance, because the project proponent is the provincial agency responsible for emergency management, we take that with a high degree of credibility and fairly seriously. We do review the rationale for the project, or the projects as they're brought forward, but the basis for our validation of that, it's relatively limited. We tend to accept what's brought forward by this provincial agency at face value.
Sorry.
Compliment that?
Yes, please.
So in the responsibility for public safety in relation to Fraser River and flood hazard management is a provincial responsibility. The funding for delivering the program lies with Emergency Management BC, and the river engineering hydrology expertise, as well as biologists and environmental impacts expertise, lies with the Ministry of Forest Lands and Natural Resource Operations.
Has there ever been an application by the province for gravel removal that's been refused in the, let's say, the last 5 years or 10 years? To either of your knowledge?
To my knowledge, not in the last 5. Over the last 10, I'm more uncertain. I'm not sure about that.
My knowledge and memory is limited to my direct involvement, and the whole committee structure was really brought about in order to look at the literature coming in regarding potential sites and to select and move forward on sites that met our criteria regarding flood protection and also minimizing impacts to the environment. So the whole point of it is to try and have that discussion early so that we don't have applications come in that at the end of the day end up getting refused. So a lot of those discussions happen before the applications are actually finalized and submitted by Emergency Management BC.
So First Nations who are weighing the potential implications of this would like to assess from their own perspective the pros and cons associated with gravel removal. Who's going to provide them the information necessary as it relates to public safety?
Emergency Management BC has been providing the information directly as the proponent, but also working on behalf of the provincial government agencies in order to try and bring about some rationalization of all the communication coming from different agencies to First Nations. So they've been taking the lead in providing that information at very early stages.
Okay, we're going to dive into that a little bit more. Could I now go to Exhibit 1076, please? This is the letter of agreement that, as I understand it, is presently with the extension more or less in operation between the parties. Is that correct? I know you're presently working on a revision, but do I have that correct?
I'm not actually sure if that's the current version or not. We are operating under a letter of agreement that has expired, but still following it in terms of spirit and intent. I just don't actually recognize this particular version of it, but it's reflective of the content of the letter of agreement as we understand it and follow it, I think.
I would concur with my fellow DFO colleague. I'm struggling a little bit to place this particular version in comparison to the final signed version.
Sorry, Mr. Commissioner, from the evidence earlier, that's how this exhibit was tendered, so that's my understanding of this exhibit. So let's proceed with that, and if I'm incorrect, we'll try to correct the record on that. I'd like to go to tab, or bullet number 3 under item number 1, and that bullet recognizes that decisions on gravel removal must respect regulatory and consultative requirements of the federal and provincial government decision makers, correct?
Yes. From the federal side?
Correct.
Yeah.
The provincial side.
Thank you. And you'll agree that that will include obligations to consult with First Nations who may have interests and impacts associated with these gravel removals?
Certainly from the federal side, that's a fairly standard expectation for any project that we're reviewing that has a regulatory decision, and this one's not treated particularly differently.
From the provincial side?
Agreed, absolutely.
All right, so then can I go to tab or Exhibit 1093? This is the draft LOA, and it now says that EMBC will lead the consultation on this program, if I've read that right. And so I'm just trying to understand, as between DFO and EMBC, who's the primary lead agent for consultation with First Nations regarding potential impacts of gravel removal on Section 35 fishing rights? Who's the lead agent?
Well, I think from the DFO perspective on this, what we try to do is work cooperatively with the province and the parties that are interested in consultative exercises on this particular project. And we try not to duplicate or overlap with consultation on issues or specific subjects that are already being attended to by the provincial government. So the approach that we take on this particular file is to understand what EMBC is doing in terms of their consultative effort, and then we do a follow-up before we issue our permit, presuming we're going to issue one, to make sure that the issues that a First Nation would have been adequately considered. And if there isn't something that has not been addressed to that point, that's our opportunity to hear that and to do our best to attend to it.
Certainly, yes, from the provincial perspective, there is a consultative framework for all the natural resource agencies that the province has brought forward. It's been in effect about 1 to 2 years at this point, and it's available on the internet as well for all to see. And Emergency Management BC is working under that framework and has taken the lead on behalf of the provincial agencies in ensuring First Nations are communicated with on the applications and further discussions. That doesn't preclude any of the individual agencies from attending meetings or participating in order to provide more information or drilling down and dealing with specific issues and concerns that are raised by the First Nations. So we're really taking a collaborative view, but or collaborative approach to the consultation, but having one lead contact to simplify the process for all the parties.
So who is that one lead contact for First Nations? Is it EMBC?
It's Emergency Management BC, correct.
So it's the proponent,
Correct.
not the decision maker.
Correct.
Okay, so then now can you explain for the Commissioner and for myself, which of the agencies determines the list of First Nations that are going to be consulted and the basis on which you will consult?
From the provincial perspective, there is a standardized list of all First Nations and mapping all the areas of interest that the different First Nations have put forward for our consideration in ensuring that we consult with them in certain areas of interest to them. So that list is, again, it's available for the public to see. Emergency Management BC, MOE, and FLNRO are all referring to the same list. So the list is determined at or clarified at a corporate level, and we deliver on that by ensuring that all the First Nations that have expressed an interest in that area are consulted with.
And on the DFO side, I think we generally align with that, but there have been times when there have been representations by different First Nations entities than are reflected in the provincial list, and DFO's approach is to generally be open to whatever party wants to represent themselves in that regard and hear what their input is and attend to it as we're able and as is appropriate.
Perhaps maybe then we can go to Exhibit 1096, where the concern was, and perhaps I'll just raise the concern and you'll see it reflected here, is are you using a determination of those First Nations who have either reserves or fishing sites, so geographical locations close to this? Are you keeping in mind that the salmon are migratory species and that people, First Nations, other than those close to the geographic site, will have an interest?
I'll speak from the provincial perspective. The Ministry of Aboriginal Affairs, Aboriginal Relations and Reconciliation, have worked with all the First Nations and obtained maps and determined their areas of interest. And in this particular area of the Fraser, the First Nations that have an interest in this area are also located on Vancouver Island. Everyone who has been identified as who has self-identified as having an interest in this area, and all the First Nations have been contacted in order to create this database. Are contacted in the course of the referrals and the discussion on these applications for gravel.
So if you then go to page 2 of 9 of the same document, there's a list of the First Nations who were consulted, as I understand it. And it seems like quite a short list, very much located. And for example, my client, the Chehalis First Nation, is not listed there. And of course, they have an interest in the migratory resources that are migratory species that may be using these gravel reaches. So could you help me understand that?
Can I request just that it be scrolled down just a little bit further so I can see the full page? And could I see further of the complainants? Okay, thank you. If we could please return back. I'm sorry I can't answer that question directly. To the best of my knowledge and my understanding is that we've been consistent with the list of First Nations that have expressed interest in this area as worked through by the Ministry of Aboriginal Relations and Reconciliation.
And from the federal side, well, I can't speak specifically to this particular document. The approach that we take is a very inclusive approach, and we recognize that there may be First Nations interests that are not immediately proximal to where the gravel removal is happening that could have some kind of ancillary effect from these works. So I don't think we're sort of going up and down the entire coast or within the provincial jurisdiction and asking everyone, but the door's open, and we're First Nations such as Julia mentioned, the Cowichan, have said, hey, we've got some interest here. Could you tell us what's going on? And we would like to be engaged prior to decisions happening. That door is open, and we do our best to fulfill that interest. So I think we're reasonably comfortable that any First Nation concern has an opportunity to be presented and to be addressed through the process that we have. And there's certainly no limitation by way of the process as we undertake it right now. So no one's excluded intentionally.
And is, in your view, Mr. Wong, do you think the existing processes and the timelines allow for sufficient time to engage meaningfully with First Nations?
To date, from the way we have seen concerns brought forward, they seem to have been reasonably addressed. The concerns that I'm aware of that First Nations have tabled, they have largely not been. They've largely been addressed by way of their engagement through the EMBC lead. But I think overall, whether it's First Nations or any other interested party, the timelines are very tight at certain phases of the permitting. But to my knowledge at this juncture, there hasn't been a significant First Nations concern that has not been able to be addressed to this point.
I wonder if I could go now to Exhibit 1094. And these are questions now for you, Mr. Wong. This is a memo that you prepared, is that correct?
Yes, that looks familiar.
Yes, and my reading of that memo was it was an opportunity for you to gather context and some of the challenges associated with this program and make some recommendations around that. Is that correct?
Yeah, it was basically a snapshot of the current status of the file for the basis of a discussion I was having with Program Director.
So I'm wondering if you could help me with a couple of these bullets, or help us all with a couple of the bullets, because in the first two bullets, you clearly recognize that there are late applications coming in. There is not have been receptive to consultation with external interests in the past, and significant levels of concern regarding the lack of information and onward. And I wonder if you could explain to us the nature of the concerns that you're having in the context of this program.
Those bullets in particular are with reference to not to First Nations, but to primarily environmental non-government organizations. And there has been an ongoing tension and difficulty in terms of at least in my view, the provincial approach and the ambitions or expectations of these non-government organizations. And I think the federal government and provincial government have agreed that we won't necessarily be perfectly aligned on this, and the points that that these bullets are speaking to are trying to raise that as an issue of concern. Because if DFO were to stand down and just kind of leave the scope of engagement at the level that the province is comfortable with, there would be parties, in particular these non-government organizations, that may not be as engaged as they would like, and that may pose some problems for DFO's regulatory decision making. So in that regard, DFO recognizes that there's a gap, and we do our best to, on our own accord, meet with these parties that don't feel they're getting the opportunities that they would like on the provincial side. So that's the essence behind those points.
But perhaps you might agree with me that if you're getting late applications and there's challenges associated with the consultative process between you and the province and the exchange of information, that's only going to compound the consultative process with First Nations in a timely manner.
Certainly anything that constrains the timelines does make the consultative process more difficult. But again, I think on the First Nation side, as far as we're aware, there has been a fairly active engagement from the province, particularly led through EMBC, and to date we have not seen significant problems or unreconciled issues come about through the course of the projects. Now,
in this memo, you also, and for some reason my note doesn't have this, but you also make a note about that this file, and by that I mean, I'm assuming you mean this gravel process, may follow a new track for future EAs. And I want to just pick up on that because I think that's important given the best practices information we had during the science panel on gravel. And perhaps you could just briefly talk about the potential new track for future EAs that you're referring to.
The current EA, or environmental assessment, pursuant to SIA, is the approach that is being taken is to take the site-specific sediment removal projects that EMBC tables and look at them as essentially as one-off or as they come year by year, independent projects. And one of the considerations that we have been evaluating is, are there more effective and more comprehensive ways to do those environmental assessments, recognizing there's a linkage between any individual sediment removal project and the other sediment removal projects that will happen within that reach, and the projects that have happened before and the projects that will happen into the future, assuming that this work continues. So we've been contemplating things like a more cumulative kind of environmental assessment. My counterparts in Ottawa, who we sought some advice from on this, called it something like I think they call it a super SIA or something like that. That would be, or super screening, that's what it was. It would be a screening that looked more comprehensively at a plan to remove sediment removal that may not have all the detail of any given year populated, but would provide more of a full context in terms of time, scope, and scale of the works. And we haven't arrived at a landing spot for that idea at this point, but that's the concept, is to take the single site-specific current approach that these environmental assessments are done on and try to make it more comprehensive to the timeline and the cumulative scale of these projects.
So in the science panel, we heard that there were suggestions by Mr. Church and otherwise in written form, and Dr. Rempel endorsed these, that a longer term period for review and consideration of these gravel applications would be useful. In fact, a minimum 10-year period was talked about, and it included and I'm wondering whether or not this super SIA or some kind of approach like that would help us as a way in to develop a more 10-year or longer-term plan that included better baseline data, measures for effectiveness, all of the kinds of things that have been talked about as the best practices. Is this the way through it so that we can look at more cumulative and comprehensive ways?
It may be, and the points that you describe are the concepts behind considering that approach. Those are the kinds of advantages or benefits that not only DFO, but I think EMBC and many of the stakeholders, I use that term generally, and as well as First Nations, I think it would address points that a number of parties have raised over time in the context of this sediment removal file.
And it would help in the consultative process, so we're not dealing with annual applications, would actually see some, well, we probably will have still some annual things to do, but we would see the overall picture and be able to have an understanding of the overall picture in a much more comprehensive way. Is that correct?
I think that's the hope, or that's the idea, if we were to land this that way, is there would still be site-specific project information to review on a year-by-year basis, but it would come nested in a more comprehensive plan framework that would have an evaluation based on a longer time scale and broader sort of reach level consideration of effects and impacts.
All right, I just have a couple more questions on this. Would you agree that in that context, and perhaps given the earlier comments, this is already more clearly happening, it's the proponent that would be responsible for putting together the materials and ensuring that First Nations have a proper basis of being able to review a longer term project? So it would be EMBC that would be doing that type of work?
Well, from DFO's end, I think they would be the primary starting point for that. It's not to say that that would be the entirety of that kind of information exchange, but they would be the first place, and probably the majority of information would start with them.
And to add to that, I would say again, Emergency Management BC as an agency of the province is doing that work, wearing the provincial agency hat and following the guidelines, and meeting those requirements on the behalf of the agencies that are making decisions. So while Emergency Management BC is taking the lead on providing that information, they're certainly getting guidance from decision makers as to where more information is required or any other requirements that we need to meet as part of the decision-making process.
To the extent that DFO and EMBC and others and other agencies are developing technical and monitoring committees to consider and review these, would it be useful to have First Nation representatives sitting on these committees directly, so that we have their input at the source, and while you're considering these applications as distinct from responsive to applications?
From the federal side, it's an option that has been considered, and I don't think it's been ruled out as a possibility. I think until we develop the thinking further around what that framework would look like and how it would link into regulatory decision making, I don't think we're in a position to make a final recommendation in that regard. But it's something that certainly it's easy to see the potential benefits and advantages of that, but it would still be necessary to do more thinking and work before we could decide if that was a viable approach or not.
From the provincial perspective?
It's one of a number of options that we're considering. Where we're going to land on that really needs to be an ongoing discussion with the First Nations. As you can see from the referrals, there's a considerable list of First Nations to engage, and even going back to the question that you asked regarding one particular nation, I failed to note that Stolo Tribal Council and the Stolo Nation represents, again, a number of nations under those umbrellas. We've been having, and EMBC has been having, ongoing dialogue with the First Nations as to how best to engage and involve them in that process. And there's different ways that we can do it, and that's still under discussion.
So you're open to having them sitting on these monitoring and technical committees?
I'm not altogether sure that these committees will continue on in their present form. That's part of the discussion within the context of a longer-term plan. So that's why I'm not saying definitively First Nations should be on those committees. We're not even quite sure that those are the right committees to bring us forward into the future in the longer-term plan, and we're discussing that and also having that dialogue with the First Nations.
All right, I just have one final question, and it's a question of related to Exhibit 1093. This is that draft letter of agreement again we've had it. I was just curious about a line in this letter of understanding, and I'm not going to ask you for a legal opinion on it, but you'll see that at the last paragraph, oh sorry, first page, you're right. The sixth paragraph in, there's a suggestion that this agreement doesn't fetter the statutory responsibilities nor abrogate or derogate from Aboriginal treaty or other rights of Aboriginal people. As people that have been working on this letter of intent and thinking about what was your goal in that What was the concern or the goal that you were trying to achieve in that clause?
Well, as I can recall, it's been a while, but as
Mr. Commissioner, I'm going to object to that question. I think the statement speaks for itself as to
Well, then I'll have
what
to
it's about.
pursue it then. Again, this is a letter of agreement between the federal and provincial crown as it relates to gravel applications that have the potential for impacting First Nations rights. So what was the goal in that clause?
But, Mr. Commissioner, the basis of objection is that this is a legal opinion with respect to this agreement. It just speaks for itself.
No,
Nothing in
I
the
appreciate
agreement.
that the legal issue may speak for itself, but I'm trying to figure out what the concerns were from the agency's perspectives who were drafting this letter of intention between them and what they were hoping to achieve. I can appreciate that there's a legal issue there, but they know they have to consult. They've already talked about that, and they know they may have an impact, and so I'm not sure what you were trying to do in this. I mean, if you don't know and if this was recommended to you by lawyers, then fine, we'll sit down. But if there's a concern that they were trying to address, I think it would be useful for First Nations to know that.
Mr. Timberg, that's how I took the question, was not that they were being asked for to give any legal view, but simply whether there was something that they were directly involved in that would have given rise to that clause, or their understanding of that clause in terms of their activities. But I'm not sure whether they were involved or they have any knowledge about that. So, but I do agree that they ought not to be giving an opinion on that clause. But let's see if, first of all, if they have any foundation for giving an answer.
from my recollection, Ms. Gartner, the point that we were trying to reflect here was just to ensure that by way of pursuing this kind of agreement, and it's important to recognize this is a draft. It's never been sort of vetted through the respective legal reviews in other parts of the organizations. But the point was not to fetter or impair or compromise the statutory obligations, the consultative obligations or standards that any of the participating parties would have. So, if ENBC wanted to do it one way and that just didn't meet the federal government's scope of how we needed to pursue things, that we were free and would not be restricted by way of this agreement to go and do what we thought we had to do.
Thank you. That's very helpful. Is there anything that you'd like to add from the provincial perspective?
Yes, I don't recall any concerns that specifically led us to include, to discuss or include that clause. It's actually terminology that I've seen before in other documentation when you're using, again, probably suggested by legal counsel at some point in drawing up these documents so that statutory decision makers have a point of reference should there be any concerns regarding fettering in any way in their decision making.
Maybe just before I sit down, the most sort of useful thing in some ways is this possible way through of looking at a 10-year plan or looking at something more comprehensive. Is there any other options that are available other than the SIA that could get us there?
Yes, certainly. The SIA is it's sort of a component of the regulatory review process, and I think the approach that we've been working on in the background over the last 8 to 12 months or so has been more of a planning-based approach where the proponent, ENBC, would develop this longer-term plan, and then we would review it under whatever the appropriate regulatory frameworks and mechanisms existed. So it didn't necessarily require a specific tactical approach under SIA. The plan would just come forward that way. So it doesn't restrict the opportunity only within the bounds of what SIA's organization is. There's other ways to approach it more comprehensively.
And does the province see the value in approaching it more comprehensively and developing a longer-term plan?
Certainly, we've been trying to work towards that for a number of years.
And what are the limiting factors?
Time. There's X number of staff that have been assigned to the portfolio, and we do the best that we can on a yearly basis, and we've been struggling to find the time to plan the longer-term plan in the context of also working on the annual applications.
All right. Those are my questions, Mr. Commissioner.
Thank you very much, Ms. Gardner.
Thank you. The province advises they have no re-examination. Does Canada? No. So we're complete on questions. Thank you very much.
Ms. Berardinucci. Mr. Wang, thank you very much for making yourselves available this morning and to answer Ms. Gertner's questions. Thank you very much.
Thank you. And Mr. Commissioner, maybe we could just stand down for 5 minutes and come right back. Thank you.
Thank you.